What a treat it is to have both of you back. We had gathered about 8-9 months ago to discuss another serious topic, and here's another big one. Now, I've been doing this job for about 15 years, and I did a tabulation the other day. I've done 18,000 television debates. And if I look back and think on how many of those 18,000, we're always demanding harsher laws for everything. And then we are faced with the premise that actually maybe in certain cases the laws are too harsh. And sometimes just doing a little bit of reform here and there is not good enough. It needs a holistic look. As you know, perhaps the biggest attempt at this is being made with a review of the IPC, which has gone to panel now. I don't assume it happened very soon, but it's a process that is mind-boggling in just imagination. Our first instinct was that all of us are so used to 302 and 420. What is going to happen to reporters if they actually change the IPC? So let me start with the premise of something that's already happened. In the lots of things that happen in Parliament, you might have missed the Jan Vishwas bill that was passed. And that was a measure at decriminalization of a lot of offenses. Can you stop putting people in jail, and can you actually fine them instead? And a person who's very knowledgeable on this and to discuss this and going ahead, of course, Mahesh ji is with us and Vivek ji is with us. Mahesh ji, tell us a bit about the logic of Jan Vishwas and what have we managed to achieve in terms of decriminalization?
Well, most of the offenses which we sought to decriminalize, they were not serious offenses. But, we have such a heritage, a colonial hangover of offenses which were so unnecessary. The Boilers Act, offenses pertaining to railway. I mean, what we found during the course of our analysis was that the railway magistrates courts, and Vivek and me were on the committee together, had the highest backlog. And that was because the amount of cases on ticketless travel and, beggary on the platforms. So the idea was basically twofold. One was where the offenses were not serious but were punishable with jail sentences, to remove that and make them punishable with either fine or just pure penalty. Get them out of the criminal courts altogether so that, A, trivial offenses don't clog up the courts. And also, they are trivial offenses. And the trend as far as trivial offenses is concerned is reformative. So community service is one possible prescription for that. And the second was where there were, fines to decriminalize them altogether. Mm-hmm. They were not worthy of even being called offenses. So as I said, British relic which needed to be changed. The latest change which the Home Minister has brought about in the Indian Penal Code, the new Indian Penal Code. Yeah. By the way, cheating is not going to be 420, so forget your Raj Kapoor and Shri 420
It's a major problem, I will have to consider it, but all in favor of a new world. Vivek ji, there is a conceptualization that oftentimes when we are asking for harsher punishment on everything, we get disconnected from the reality of what we are actually asking for. And I think all of us are very attuned to the fact that the justice system is overloaded. What does decriminalization of petty offenses mean there?
Thanks, Rishabh. This is something which actually touches my heart. Let me start with a small story. There's a gentleman called, he died 1 year back, General Chaudhary. A Second World War hero, Kashmir hero, China War hero. I mean, he's fought all those wars, up to 71 Pak. He retires as a general of the Indian Army, lives in Delhi. One day, some strange man from the municipality says, there's a fossil in your house. This fossil he had bought from the house of Raja Bharatpur when he had gone visiting him 40 years back or 50 years back. A charge sheet is filed against him in Tisazari. The general is about 95 years old and Mrs. Chaudhary is about 90 years old. They went 20 times to Tisazari for an offense which possibly would have led to some fine finally. The general broke down. Since he was a family friend, we intervened, we spoke to the judges, and we somehow brought a quietus to that offense. There are hundreds of General Chowdhuries in this country who face the ordeal of a court. This Jan Vishwas exercise, and I must tell you, our chairman, Mr. Chowdhury, and we were both members of that, it was a wonderful exercise done in a very short time, where we went through 80 acts, I think, or 44.
179 provisions.
79 provisions, but 44 acts. 40, maybe more.
Almost 100.
Lot of enactments. And what were we looking at? Something which really doesn't matter today, but you still get charge sheeted in court. There are hundreds and hundreds of provisions across various enactments where it really doesn't matter. It'll end up in a 500 rupee fine or a 50 rupee fine, but there will be a charge sheet in court. You'll have to engage a lawyer from summons.
I was about to say you're reducing the work for lawyers.
They get paid more than the fine.
So what happens is you eliminate all this. There's a system that instead of a court trial, you end up with a penalty. It's like when you are driving a car, you're not wearing a seat belt, or you've overshot the zebra, or you overshot the red light. Now, do you need to go to court for that? You get a challan on your mobile, you deposit that payment, and it comes to an end. So it's basically making life easy for our citizens. This is a thing which should have been done long back, and these were old enactments, and we have the largest number of laws in this country.
So Vivekji, one is the law itself, and the other is, of course, then the application, which is oftentimes a little bit of harassment, and that's what it begins. Because if you find one thing wrong, then you hunt to find 10 more things wrong. So at least a fat list of accusations can go. If you commit one traffic offence, the traffic constable will try to find at least 5 others.
You look at your license.
Yeah, everything, license and RC. We are all routine to hear it, right? That's what we ask for. So they can find 5 more things to implicate. So what about the application part of it? Does it send out a messaging that we trust the people, and to be honest in the get-go?
Where I feel that we may have overstepped is because in our anxiety to make things easy, I later on found that there were some consumer federations and other associations which were protesting that some offences, by removing the concept of imprisonment and fine and only relegating it to penalty, we have actually removed the deterrence which should have been there for that punishment. There were people who were saying that. Maybe in our anxiety to do a larger job, we may have missed a few sections where we may have overstepped. But as I said, overall, it's for the betterment of the system. It's for easy operation of...
Okay, but in your experience, Mahesh ji, are there going to be a large number of people who say, okay, penalties being put on me, I'll pay it, or are there a large percentage of people कि भी नहीं देता, कर लो जो करना है, what are you going to do?
No, I mean, if you're talking about deterrence,
yeah.
Let me tell you something, that changing these laws were not meant so much for deterrence as they were to make sure that the court's arrears were cleared up, right? And also to take out the chap of being a criminal from really petty people who are not really criminals. These are, offenses which are petty. But if you're talking about deterrence, the real deterrent measure in this country which is required is to speed up justice. I was on this criminal law reform committee for all these 3 statutes. And by the time it got to the Home Ministry, we had made very beneficent provisions. This was during COVID, So I had a lot of time on my hands also to do things. And we examined all the provisions. There were young college students who were assisting us. And we tried to get timelines for everything, for finishing investigations. Because ultimately, look at the amount of serious crimes that have taken place in this country. And look at the time lag some of them have not even started. They're about 10, 15 years old.
Yeah.
So where is the deterrence?
So what's broken in the IPC, in the Evidence Act, everything which in the criminal procedure, everything we want to look at, what was so fundamentally broken that we say, let's start with the fresh plate?
No, look, as I said, the language of the, for instance, the Indian Penal Code, there were frequent references to Her Majesty still. That colonial legacy had to be wiped out. Substantively, there were some provisions, some new laws. For instance, in the Criminal Procedure Code, you needed, electronic evidence to be incorporated, police stations, videography during questioning. All these, with some of which came through judicial interpretation, which said that these things must be done. So progressive legislation, which has come with passage of time, advancements, right? All this needed to be incorporated. That's part of it.
Okay, so Vivekji, is it required? Do we need incremental change, or do we look at IPC and 3 major acts, in which means everything, young lawyers will have to start a lot of things from scratch? Do we need that scale of an interjection?
With utmost respect to my friend,
Yes.
who was member of the committee which drafted it. I think Professor Rajkumar was also there, no? With you. I saw that committee, which drafted this in these
Yes, yes.
Anyway, these are very illustrious people, but I feel that one, I don't think you require to change the laws completely, revamp the laws, because we've also got used to those laws. There's a jurisprudence which is built behind those laws. Those sections are embedded in our mind. IO will now have to search for which section he wants to book somebody. I mean, today, after these laws become the law of the land someday, the IO will be faced with a new situation. He would for now 302 is a well-known section, 302. Now, there is no 302, it will be some other section. Cheating is something else. Sedition is something else. So these changes, I don't think, and when I saw the number of changes that were made, I realized that substantive sections in a large number of cases have been retained. What is changed or amended is much less. So even in Evidence Act, for instance, the changes are 17. I have the numbers, I'd done that comparative reading. So I feel that without getting into this argument of colonial legacy, because this is a law which is followed by the whole Commonwealth nations. I mean, this jurisprudence was evolved by the British, yes, Macaulay and others, in the 18th century, 19th century. And then later on, all the entire Commonwealth, the entire democratic front, I mean, is using these laws.
So that's the question. So I mean, there's inconvenience. As I mentioned, I began with this premise that we are going to face the same problem. But other than that, at what point of time? Because we found an odd irony when the issue of Nirbhaya was going on, and I was interviewing her mother on a different occasion, and she mentioned that look, so many years have elapsed, and a loophole technicality has been found by those who've been convicted, and that the sentence can't be carried out unless your mercy petition is decided. And if you simply keep delaying your mercy petition and never submit it, it cannot be decided. So there are loopholes. How much can we incrementally plug as we have for all these 100 or 100 plus years? And at what point of time do you need? Let's figure this out again.
For that, you don't need to bring a new act. There were so many amendments which were brought in 100 years in these enactments. CRPC is about 50, 70 years, 60 years old. It is, I think, 1773. IPC is 1867 or 70 or something. Evidence Act is also 1800 and something. So over a period of time, I mean, you see if you read the sections of the Evidence Act, see the formulation. You could hardly find a mistake with those formulations for 100 years. If somebody's done a good job, why do you take it as a colonial relic? Take it as a good education.
Okay. So in the examination of this, you mentioned the semantical issues and some, of course, the updation issues. But in substance, Maheshji, what did you find as a committee that required an interjection, that this requires us to do something special?
Well, that was the whole purpose. The whole purpose of getting the new laws was not just a nomenclature change or changing sections. And, if you change sections, people get used to it. We had a criminal procedure code in 1898. We got a new one in 1973. In between, you had a temporary one from 1931. So people get used to section changes, We might miss 420 and 302, but ultimately, it's the substance, not the nomenclature or the number. What we really require, the thrust of all criminal reform should be speedy justice. That's not happening. Now, in the civil domain, we've got the mediation bill, now become the act, right? Where we've got compulsory mediation. But, when we interfaced, and we were both there and part of the Law and Justice Committee, when we interfaced with the Supreme Court judges, Justice Chandrachud and Justice Ramana, who was then the Chief Justice, we said, look, we can bring all these changes about, but if the delays don't stop, and the judiciary also has to play its part. Now, people file false defenses. Why? Because of arrears. They know that, if you file a false defense, if you don't speak the truth, if you produce forged documents, there's no incentive for any litigant to hurry up with this case. So the wrong party in a case is always going to use the inbuilt delays in our system to delay it further. That's where the judiciary comes in. Yes, we can legislate as legislators, right?
Yes.
We can bring in new reforms. I try to put in timelines for each stage of a trial, investigation, charge.
Is that possible? Is it possible to put in that timeline?
Yes, it is possible. But the problem is, again, this. There are two problems with timelines. One is that you don't have enough manpower. Right? You have a plethora of cases, right? New offenses coming out. Now, cybercrime is a new offense.
So is there something which reduces this? I'm going to ask about, of course, community service after that. But something that reduces the court work as Jan Vishwas is trying to do on petty offenses?
Yes, of course it reduces, because some offenses are taken out of the canvas of the court altogether. Yeah. So it's bound to help. Right?
Okay.
So Jan Vishwas was, fortunately, a stupendous task and very useful. Right? Amending the law, the IPC, bringing in some new offenses have to be brought in to reflect changing patterns of crime, cybercrime, and so on and so forth, right? Electronic evidence, so the Evidence Act has to be amended. But ultimately, you need more judges to decide, and you need more police staff
so let me ask
to investigate.
Let me ask the controversial question. Vivek ji, somebody once mentioned to me that not facing the harassment of a long drawn-out court procedure itself is a deterrence. That if you speed up things, people will find that, that's going to court is a day in and a day out, so it's not a problem. Is that a mindset because we got used to it? Is it a problem that can be solved through legislation per se, or is it just a manpower problem?
When we were debating the mediation bill, and they said we are going to make mediation for every trial, every commencement of trial, in the civil jurisdiction also, compulsory. My question is, 1,000 cases are filed in the country every day. Do you have 1,000 mediators to sit and mediate every day? You have 1,000 courts for that, or courtrooms for that, or the staff for that. Who are your mediators? I mean, you have a small group of 10 people, or 15 people. So these are big thoughts. But the point is, those big thoughts will not change anything. That's what I'm saying. The 3 laws that you brought will not change anything. If the laws could bring down offenses, it won't. If the laws will speed up trials, it won't. Because the number of judges are going to be the same. The courts are going to be the same. The procedures, in Hindu Marriage Act, they say you should finish a divorce trial in 6 months. Now tell me, which trial gets finished in 6 months?
There are 2 things to touch here. So I'm going to touch on the procedural part. Is there at least, Mahesh ji, through digitization, procedural speed that can be brought in, at least through appearance of video conference appearances? Everybody doesn't need to show up at the same time. You can log in and continue with your work. Is there at least a procedural speed that can be brought in?
Yes, that's being done. Now you can have full-fledged trials. The criminal procedure code now, full trials, examination, cross-examination, re-examination of witnesses can all be conducted on video conference. So of course it's going to speed it up. Measures are being taken. Look, there's no point saying, ultimately we are legislators. There's no point saying nothing is going to happen. We have to do the best within the possibilities that exist.
Okay, all right.
That's the task of a legislature. You're optimistic. You can't keep saying, "Achhe din nahi aayenge."
Okay, concept of community service, which we are familiar with from Western cinema. First-time offences, community service. Can you describe what you mean in which categories first-time offence and what does community service mean?
Yeah. Well, community service is going to be for a very restricted category of cases, and those really consist of petty offences. Now, defamation is one of them. So, Rahul Gandhi can thank the legislation because now community service for a first-time offender under the new bill, a first-time offender is likely in a defamation case to get only community service. So this is how magnanimous a BJP government is towards the leader of a Congress party.
Okay, I'm sure he's going to say doing a rally is community service, so he's already exonerated. But community service, what is it going to be? What is community service? What will you be asked to do?
But I mean, all tasks which enhance the community's welfare, growing trees, right? Going to prisons, planting trees, going to prisons. Serving there, you help other inmates.
Okay. Does that make me a chance at a reformist, model human being if I'm given a tap on the wrist and told to go plant trees? Vivek
No, I'm not against what he's saying. Innovation is required. Changes are required. But what I'm trying to say is bring it step by step, piece by piece. I mean, changing the bill and giving them Hindi names is not going to help you argue with the South India. They're going to object. Idea is, is it a political tool or a legal thesis?
But are there provisions like the ones he mentioned, which are salutary, even if you have an overall objection, like defamation, for example, that first-time offence, community service, go and plant some trees?
No. We have even today, under their extraordinary jurisdiction, such punishments are given even today. Nobody is against that. Nobody would be against that. But that could be done also under the present enactment.
Okay. Is this, I know there might be a substantive thought on logic and idea. But is this a political issue, Vivekji? When we do legal reform, does it become a politically contentious issue? Or is this one, it's pure legality and logic?
I would say that the way it has been presented, they want to make it a political issue. There was this, if such a measure had to come, it could have gone for a larger public debate. You are changing the IPC, you are changing the Evidence Act, you are changing the CRPC. There should have been an open All India public debate. Law Commission should have been involved. And you could have then had a report of the Law Commission. That's how it happens normally. Here, straight away, 3 enactments of which we had not heard anything before. I mean, I as an MP, I'm saying that, are suddenly sent to the Parliament for discussion. Now, what I'm trying to say is that then this doesn't look that it's just an academic exercise or an exercise for the good of the people. You are trying to say that because I have changed the Parliament building, I have changed so many other things in India, so the laws must also change.
Is it change for the sake of change? Or do you feel, Maheshji, that when we are bringing about change, some people will take time to absorb it. Bringing about legal change like this, do you find it easier in terms of the politics of it, or is it also very complicated?
No, listen, I mean, it only becomes political if you are negative about any measure. Now, I mean, if you have a no work and shirk attitude towards legislation or your duties, for 75 years you brought in nothing, and the system has become worse. Nobody can deny that arrears keep mounting, right? Arrears keep mounting. So we have to find solutions. To say that nothing is going to help is a no work and shirk attitude on people who actually should take the burden upon themselves, think out the box, and find things to do.
Okay.
That's one. Right?
Should it take its own due course, or if it is to be done, were it to be done, best to be done quickly?
There is no inbuilt mechanism or some natural law of nature that is going to unfold and make things better. Part of it has got to be legislation. Part of it has got to be attitudinal. There's got to be a change in mindset as well, right? But we are getting too used, and particularly the bar is getting too used to the old system, right? I will tell you one example. when my father was the law minister many years ago, he introduced an amendment to the Civil Procedure Code. Right? And he said no more than 3 adjournments. And there was an uproar at the bar. The bar itself has an entrenched interest, I hate to say, in delayed justice. Because every time most lawyers go for an adjournment, the meter ticks. So you've got to think out of the box.
Okay.
It's in everybody's interest, but unless you get vested interest wanting to change the trend of things, it will not happen.
Like I did at the very beginning, and Abhishek ji has also just joined us. Maybe we should hold more conversations about not harsher punishments, but milder punishments. But what impacts a deterrence and not. It's going to be a fascinating journey, not just in the sections that will change, and we'll have to get used to the new ones, in the terminologies that will change, but also in conversations about how we perceive justice if community service and other things become a part of it. Mahesh ji and Vivek ji, thank you so much once again for a very topical and enlightening conversation. As always, really appreciate it.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.